I'm Sean Cooper, president and owner of Fit Financial Consulting, LLC, a registered investment advisor. This time around, we're talking about estate planning. My goal is to share with you some of the common documents and methodologies utilized in estate planning to give you an idea of when you might need them and what they really accomplish. For any more specific questions, you'll probably want to consult an estate planning attorney or another expert in the field. The first document that you're probably going to want to consider, and everyone should really have, is a will. This document specifies who your assets should pass to and when they should pass. It's a relatively simple document, but the more specific you can be in your will, the less challenges your heirs are likely to encounter when it comes to actually determining how your assets are going to be passed, and hopefully the less expensive it's going to be for them as well. Better yet, you should probably have this document professionally drafted. Regardless of whether you do it yourself or draft it with an attorney, you definitely want to sign and date the document, and ideally have a couple of witnesses sign it as well. Something to be aware of with the will is it does not avoid the probate process. Specifically, it's probably going to go directly to probate, since that's the first step in the probate process, is to gather the will. And this can be an expensive and time-consuming process for your heirs. Really consists of 4 steps. First is filing a will, if there is a will, so you file it with the courts. Second is to inventory the property of the deceased. Third is to pay all the debts, pay off all the creditors, and pay estate taxes. So all of that stuff happens before any beneficiaries get anything. And that's the 4th step, which is distributing the remaining property to the beneficiaries. As I said, this is all based in the courts, so as you can imagine, legal fees are going to ensue, especially if there's not a will or the will is not specific. That increases the chances that a beneficiary, or even someone who wasn't a beneficiary, can contest the will or contest the estate. And that means they're basically saying, no, I should have gotten more than what was specified, or I should have been named as a beneficiary and I wasn't, or this asset is mine or should have been passed to me, or the person and I had a private conversation and they said I was going to get this, or they wrote it down on a napkin. Whatever it may be, they can contest your estate, and that just adds to the time and the expense of the probate process. So all things that you want to try to avoid, and all things that these documents can help you do from a probate standpoint. Specifically, your retirement and your insurance accounts should name a specific beneficiary, which will allow you to avoid the probate process there. Your investments, savings, checking, cars, land, all of those things will default to the probate process unless there's something else in place, like the titling of the accounts to help avoid probate, or putting the assets inside of a trust to potentially avoid probate. A very easy way to eliminate or reduce the probate process is just by being very, very intentional about how you designate your beneficiaries. When you look at your life insurance or your retirement accounts, they all require that you have beneficiaries designated. You just want to make sure that those beneficiaries are up to date, especially if anyone's passed away or there's been a divorce or anything along those lines. Because both of these, the life insurance and the retirement accounts, if the beneficiaries are properly designated, can avoid the probate process altogether. I also suggest designating a specific person as opposed to your estate, since if you designate your estate, it's still going to go through the probate process. And also having a contingent beneficiary, because if the primary beneficiary passes away or predeceases you, then you have someone in place as a backup, essentially. For your non-qualified accounts, designating a beneficiary won't necessarily avoid probate. So a little bit different strategy on those accounts. So I'm talking about your individual investment accounts, savings accounts, checking accounts, things of that nature. The only way to really avoid probate on those is with the titling. Obviously a trust would help avoid that as well, but we'll get to that. But the easiest way is with the titling of the account. So you can utilize a TOD, which is a transfer on death, which, just like it sounds, Once you pass away, the TOD takes an effect and it passes to another person. It specifies that. It's very similar to designating a beneficiary. Another option would be a joint tenants with rights of survivorship, which is basically a joint form of a joint account. The advantage to this is, again, you're going to avoid the probate process because there are now effectively more than one owner on the account, and those other owners or owner will take control of those assets when you pass away, thereby avoiding probate. The biggest disadvantage is it's now a joint account. So just like a joint savings or checking account, everyone listed on that account now has control of those assets even before you pass away. So that is a limitation to the JTWROS that the TOD doesn't necessarily have. But as I mentioned, even just having joint accounts can help you effectively avoid the probate process. A more formal method of controlling your assets after you pass away is via a trust. A trust accomplishes a number of things that a will can't necessarily accomplish. It's going to specify how your assets are going to be handled after you pass away. So you can even specify how they should be invested going forward, at least to a certain extent. You can specify who they pass to, which is the same as a will, and as well as how they're going to pass to your beneficiaries. So if you don't want your beneficiaries to receive the funds or money until they reach a certain age, or you only want them to get a specific amount every year for X number of years, you can specify all of that in a trust. So it can get very complicated, but it allows you by far the most control. Because of that complexity, trusts do tend to get expensive, potentially anywhere from a few $100s to several $1,000s. And you are going to need an estate planning attorney for that process. With that said, it does allow you for the most control over your assets after you pass, so there are some serious advantages to the trust. In addition to all those other things I mentioned about the trust, you can even specify who controls your assets and who is going to distribute your assets, not just who receives them and how they receive them or when they receive them. A couple different forms of trust that you should be aware of, though, are revocable and irrevocable. A revocable trust is going to accomplish all of those goals that we just discussed, but it's going to have the added advantage of allowing you to change it down the road. So as things in your life or the lives of your beneficiaries change, you can update that trust and make changes to it going forward. An irrevocable trust is much like it sounds. It's not revocable. You can't change it down the road. So all the same benefits as prior mentioned, but without the ability to change it. Now, the one advantage to not being able to change it is, from a tax standpoint, any assets inside an irrevocable trust are effectively removed from your estate, so they don't go through and count towards your estate taxes, which can be a very big advantage, but you lose that ability to change it down the road. Another thing to be aware of when it comes to trusts is you can put assets, hard assets like cars, houses, and things of that nature inside the trust, but if you put a house inside the trust, you cannot refinance the house while it's in the trust. You actually have to remove it from the trust, refinance it, and then you can put it back in. So an irrevocable trust would not allow you to have that flexibility. So something to be aware of when it comes to choosing which assets go in the trust and how you set that up. If you have children, another thing that you're going to want to be cognizant of and make decisions around is guardianship. So who is going to basically look after your children if you were to pass? And you definitely want to make sure you select someone that you feel is going to do a good job of supporting your kids, but you also want to talk to that person and make sure they're comfortable performing the role. If you don't set up a guardian, then typically the children will pass to the next closest relative or potentially even become wards of the state. Neither are necessarily the most ideal situation, especially if that closest relative is not someone you want to look after your kids. Some of the other documents you're going to want to consider are a power of attorney and cohabitation agreements. These are more specific documents, so it may not apply to each individual, but the power of attorney is a little bit broader. So things like having the ability to have someone make decisions for you if you're incapacitated. So they're going to make decisions on your behalf for your well-being if you're in a hospital and you're in a comatose state, or just for some other reason not able to make your own decisions. This would be considered a medical power of attorney. Another would be a limited power of attorney. So say, for example, you were going away to a foreign country and you weren't going to have the ability to control all your assets while you were abroad, and you were going to be there for 6 months or a year. So you set up a limited power of attorney so that someone local could basically take over and oversee your estate while you were gone. There are other applications to limited power of attorneys, but that's just one example. The cohabitation agreement, like I said, is a little more specific. It would be most commonly used for unmarried couples. But this agreement essentially sets forth who is going to cover expenses, who's going to cover child care, debt payments, mutual financial support, and who owns each individual asset. So it just lays that out so that if one of the cohabiting members were to pass, it defines how that other cohabiting member is going to control it versus the ex-spouse or whoever else might be involved in the situation. As I said, these are just a few examples of the documents and some of the things you can do to improve your estate planning needs. Again, the estate planning attorney is going to be your best bet for anything more specific than this. And like I said, they can get expensive. I do think they're worthwhile for a lot of people, depending on what your estate planning needs are. I'd say they're still the top choice. There are other options that you can consider though. There's a variety of different services that you can subscribe to. Legal Shield is one that comes to mind. I think there's something like $10 a month, and that includes a basic will and talk time with attorneys and things of that nature for legal guidance. Anything more complex though, and even Legal Shield is going to hand you off basically to an estate planning attorney. And the advantage is they're going to get you essentially a 25% discount to the estate planning attorney services, which can be a pretty hefty savings. On the flip side though, you don't get to choose who that estate planning attorney is. Legal Shield's going to basically sign you up with one. So kind of a trade-off, but something to consider. The real point here is though, after you pass, your beneficiaries, your heirs are already going to be dealing with a lot to begin with, especially emotional. So adding a financial burden, things that are going to throw them off even more, is not ideal. And that's really what these documents are in place for, to help smooth this process out as much as possible. If you have any questions, I do recommend consulting an estate planning attorney, but you can always reach out to me. My number is 720-808-6979, and my email is sean.cooper@fitfinancialconsulting.com. Thanks.